Lords, my lady, I'm most grateful for the extra 10 minutes. I'm very sorry about that.
Well, we took a further 5 minutes because we took advantage to have a chat about some of the issues. So we weren't wasting our time.
Well, I'm pleased to say neither were we exactly. What we can say from the bar, at least at this stage, on the question of time limits, is that the time limits for appeals against HMRC decisions in relation to tax credits are the same, in the sense it's a 30-day time limit from the decision, with a long stop of 13 months,
right,
with the power in the tribunal's rules, to extend time if it sees fit.
Okay, and just to clarify, as I understand it, we are talking about, when you say the tribunal, the first tier level, we're talking about the Social Entitlement Chamber.
Yes.
I believe. And I ask that because it's a different set of rules.
Indeed.
From the tax
yes.
chamber.
Tax credits, although administered by the HMRC, are generally speaking, I don't want to take this too far, and I don't think it's particularly material, treated like Social Security benefits, ultimately, in the sense that they are appealed through the Social Security chamber.
So we're looking at social entitlement rules. You referred earlier, we can find them online, but it would be helpful to have them.
Yes.
Paragraph 5 and I think paragraph 22,
yes,
which are referred to. I can see that in CJ, was it JC?
Indeed. My learned friend informed me is Rule 22 at least is in the authorities bundle, but we obviously can get a copy of Rule 5.
Well, that's just as I understand it, that's the generic power to
Indeed.
alter time limits, rather like CPR3.
My lady, yes. And there's a little bit in the decision of CJ about how that rule has been applied by the tribunal, which hasn't changed in any material way since the decision in CJ. So
as I understand that, the tribunals usually apply the Denton-like, I know they don't quite describe it as that, but it's the Denton-like test.
Yes, similar.
In deciding whether to extend time.
Yes. I mean, it might be said to be slightly broader than that. Might we put it this way, that if at the end of our submissions anything rides on any distinction that might exist between either Rule 5 and Denton, or indeed anything that might exist between Rule 5 and the position as in CJ, we'll make sure the court has anything it needs.
Thank you. Right, now, I think you concluded your overview.
Yes, I'd set out the 5
Set out your story, and then you were going to take us to the relevant authority.
Indeed.
So we're expecting to be taken to CJ, obviously,
yes,
and to Connor, and to Salim, and
yes.
Were you going to refer to any of the Henry VIII cases?
Indeed, I'm starting there, in fact.
Okay.
At Total.
So really, just to, for my benefit, perhaps for nobody else's, just to, what we're looking for, what we're having in mind is your central submission that the order in this case was out with the provision in, it's really section 1242B in particular.
My lord, indeed.
And that's what we have to provide. Right, okay, where do we go?
So if we can start with Total, which is behind tab 14. Obviously, we've looked at this a little bit already, but I'm going to take it in a certain sequence just to understand the reasoning. We began looking at paragraph 1, where it just talks about what this case is actually about. Right. And indeed, my learned friend's entirely right. It was about abolishing altogether a right of appeal that existed from the first tier tribunal to the upper tribunal in relation to hardship decisions. At paragraph 11, we see a bit more detail about what was actually done. Now, of course, what was done here was similar to what was done in our case, in the sense that it was the utilisation of the Henry VIII power in section 1, or the purported exercise of the Henry VIII power in section 124 to amend the primary legislation, which is, of course, the 1994 VAT Act. Now, as is clear from paragraph 11, which has some forensic importance, there had always been an obligation, a condition precedent, if you like, to pay tax before you could bring an appeal against the underlying assessment. What changed was that the first tier's decision about whether or not you had to pay that subject to the hardship test was no longer appealable to the Upper Tribunal on a point of law. That is the discrete question that arose in the context of that case.
Okay, and just to be clear there, before this change,
Yes.
it was still the case that if a hardship application was refused by the revenue, you went to the first tier.
Yes.
But before this change,
Yes.
you could appeal from the first tier.
To the Upper Tribunal.
Yes.
On a point of law only.
Yes.
And of course, equally true of all of that, and a very marked difference, but not the only one, between that case and ours, is the underlying right to appeal the substantive decision, the assessment, as it were, was not extinguished if you failed in your application to the first tier tribunal for a hardship dispensation, or indeed then failed in your subsequent appeal.
Okay, but is that part of the reasoning of the court? Because I mean, there was some discussion of this earlier, and there are essentially two appeal processes
Yes.
here.
It's not part of the reasoning, but it is a feature of the case, which will be relevant to my submissions in due course, but only to a marginal degree, because what my learned friend seeks to do is rely on the, we certainly say it's obiter example of the imposition of a condition precedent, as meaning that this condition precedent in this case was virus. We say that that's taking the decision in total too far, and I hope to make that good when we look at the second of the Henry VIII cases at the very least, which is the PLP case. But if I may just pick up a few points about total so I don't have to come back to it again. What I was trying to demonstrate was what the essential question was in total, partly in order to delineate reasoning as opposed to obiter, which, as we've seen, is in paragraph 13, is where the essential question is asked. And then at paragraph 16, Lord Justice Moses goes on to explain that absent the amendment to the primary legislation introduced by the order, there would have been a right pursuant to section 11 of the 2007 Act. And resolution of the question of whether or not section 124 enabled HMRC to make that enactment fell onto the question at the end of paragraph 16. Resolution of that question turns on whether the words conferring that power are sufficiently clear. Now, that might sound obvious, but what that brings Lord Justice Moses on to is the case law in relation to Henry VIII powers, which is important. And he there cites the decision of Sparth Home, which basically imposes the restrictive approach to any interpretation of a enabling power, which purports, or does in fact, give the executive the power to amend primary legislation. And the rationale for that is then explained at paragraph 80. The purpose of the requirement of the statute which purports to confer the power to amend primary legislation by delegated legislation should use clear words is obvious. Parliament should be told in clear terms if the executive intends to amend primary legislation, i.e. is it a Henry VIII power at all, and as Lord Hoffman observed in the context of the purported removal of a fundamental right, if clear words are not used, the full implications of width of the power may pass unnoticed in the democratic process. That's an argument in favour of specificity, even in the enabling power, because the wider the power, the more likely it might be misused. And by misused, I mean in a manner not contemplated by Parliament when setting down the enabling power in the first place. That's a submission I'm going to develop in due course when we look at PLP. And then the question descends into the one at paragraph 19. Does it contain words of sufficient clarity to forewarn that a right of appeal from the first tier tribunal to an upper tribunal was to be withdrawn? And then his reasoning develops from paragraph 20 to 26. And my learned friend has already taken you to some of that. In effect, what Justice Moses says is that section 1241, in relation to provision in connection with appeals, doesn't extend so far as to a power to create or remove rights of appeal.
Where does he say that specifically? 23?
Yes, he finalises that.
I mean, do you want to take us through 20 to 23? Or
Yes, it would be useful to go through the reasoning if I
Okay.
may. So in paragraph 21, this is the paragraph relied on by my learned friend. Lord Justice Moses, at least, thinks the paradigm example of making provision in connection with appeals is the example given in section 1242, which, as my Lady Justice Falk indicated, was almost like an example of how the power might be deployed. And that is obviously to use it in ways to make provision about the circumstances in which an appeal may be made. Now I'm going to refer to that, if I may, as the condition precedent power, because that's, I think, what my learned friend is effectively saying about it.
Sorry, which power is the condition precedent?
Apologies. Section 1242A2, which is the make provision about the circumstances in which an appeal may be made.
Yes.
Because what Lord Justice Moses is using as an example of the question of obiter is if you put a condition precedent in the way of an appeal being entertained, payment of tax, that would be a legitimate deployment of that power contained in section 1242A2. And
So it's the first sentence of 22, isn't it? You're going to rely on.
yes, well, that's
the assertion, that's your submission.
yeah, that was our submission, and is our submission as it was set out in the respondent's notice. But what I'm going to seek to do is to explain why my learned friend has not answered that submission in such a way as to mean that subsection 1A of section 38 is inter vires. So I need to develop that. But at the moment I'm acknowledging that effectively the high watermark of my learned friend's case is to say, there is a power, clearly, in section 124 to impose condition precedents on the enjoyment of a right of appeal. And that is qualitatively different from the power that doesn't exist in 124, which is to remove rights of appeal, or indeed create them. Now I understand that, and I'm prepared for the purposes of argument this afternoon to accept that might be right, but it's not an answer to this case, and that's of course what I have to make good. But if I could just carry on with this case and so that we can put it to one side and return to the other cases before I really come back to my main submissions, which I hope will be crystal clear by the time we get there. But true it is that Lord Justice Moses gave us an example, the payment of tax, which of course had already existed as a condition precedent. It didn't require these amendments necessary to introduce it, but nothing necessarily rides on that. And then just pulling down to paragraph 26, just to really make good the application of the restrictive rule of interpretation when dealing with the Henry VIII clause, he recognises in paragraph 26 that a benevolent construction of the provisions might have permitted the making of the order that was in issue in that case. But as he says in the last sentence of that paragraph, that the need for clear words precludes any such benevolence. And then you see the ultimate conclusion in 27. So that much we understand. I shall come back to its significance in terms of this case in due course. But if we could just turn now to paragraph 32 of Lord Justice Moses' judgment, where he deals with the discrete question of whether or not what was an issue in this case engaged fundamental rights, or was an interference with fundamental rights. And we know that he concluded that it did not. And the reason for that was the nature of the right that was being lost. This was effectively a right to appeal on a point of law to the Upper Tribunal that had been lost, but in return, one had a right to judicially review on a point of law. So that's why Lord Justice Moses concludes that it's highfalutin to suggest that this is some If only we could get that into one of our submissions, I thought.
Well, you managed
to get into the yeah.
That was. I assume that wasn't for a bet.
No, indeed it wasn't. I just enjoyed saying the word. But it's important, of course, that what he's saying here is not that fundamental rights aren't engaged in the context of tribunals and appeals to tribunals. He's simply saying in the narrow circumstances of this case, this doesn't engage the question of fundamental rights. And in due course, of course, I'm going to submit to you that our case does engage fundamental rights, and that has important differences. But even if it doesn't, we've still got to apply the Spath-Home approach to interpretation of the enabling power, because we're in the territory of Henry VIII.
Yeah. Do you want to say anything about what he says at the end? Last part of 32. It's the right lost is the right to appeal, only with permission on a point of law. Since JR is available, Total were not deprived of a very great deal. So, how do you distinguish your situation?
Well, because what we're losing in the context of our case is the right to a full merits hearing on the basis of the current evidence before a fact-finding jurisdiction. And in that context, the case law is clear, that engages fundamental rights. And I shall take you to the authorities for that just shortly. All I was doing at this stage was just making sure we understood on what basis, well, Justice Moses said fundamental rights not engaged in that case.
Right.
And the final point I wanted to take you to on this part is, and again, this is just really for clarity of the analysis, that at paragraphs 33 and 34, Lord Justice Moses indicates his regret that he's taking a different view from Mr Justice Simon in terms of the enabling power and its scope. And then in paragraph 34, he highlights the fact that the error that was made by Mr Justice Simon below was to look at whether or not there was clarity of words in the purported exercise of the power. And he says, well, that's all well and good, but it's irrelevant. Precisely the same in this case.
Okay, I don't think that's really in dispute on the ultra vires.
I agree, my lady. It's for clarity of analysis. I just want us to be absolutely clear that what we're looking at, and will only look at, ultimately, is section 124 and whether or not it does enough. And I'm going to come on to show you what it needs to do in order to be enough in a moment. If I might then take us to the second case on Henry VIII powers, which I can deal with relatively briefly, and that's the PLP case, which is at tab 17, decided in 2016. Now, just so you have them available, it's really the statements of principle I'm relying on this case for, but just so you know where they are, the enabling powers in the context of this purported deployment of the Henry VIII power was section 9 of LASPO, which is at paragraph 5, which is at page 418 in the authorities bundle. And you'll see the Henry VIII powers in subsection 2. The Lord Chancellor may by order add services to part 1, which is where all the legal aid services were listed, or B, vary or omit services described in that part. Now, what the Secretary of State had purported to do, and was under challenge in LASPO, was utilise that power to say people who were from abroad couldn't access legal aid as a blanket rule, effectively. And we see the second of the powers that was relied on at paragraph 8, and in particular subsection 2, or subsection 1 and 2, really.
Sorry, paragraph 8 of
paragraph
the
8 of the
judgment.
Yes, so page 419. So I'm just here taking you to the two powers that were in issue.
Are you in the Supreme Court judgment?
Oh, I apologise. Yes, I am.
Page 419.
Yes, I'm sorry. Yes, these reports, of course, always have the full text of the Court of Appeal judgments beforehand.
Okay, so just row back. The first extract you read was section 9, was it?
Yes, in paragraph 5 of the Supreme Court judgment, I believe.
It's also in the Court of Appeal.
Paragraph
Okay,
5.
sorry. Probably the same paragraph as well. This case is, I mean, anyway.
Anyway, here, we are, and here it is, 8.
Yes, 418, paragraph 5, and then again at paragraph 8, page 419, are the two enabling powers. And what I want to say about those, if I may briefly, is they're very broad powers.
But they're also very general, aren't they?
Well, that's effectively what I mean. They're general powers. The question, obviously, ultimately, was whether or not the purported deployment of those powers was within those general powers.
And do we look at any particular part of section 41? All those parts?
It's 1 and 2.
1 and 2.
Subsection, section 41, subsection 1 and 2.
I'm most grateful, my lord.
Is that right?
Yes.
Okay,
These are just illustrative.
Should we read this? I mean, it's...
Well, it will help you understand exactly what the Supreme Court in this case concluded. The reason I'm taking you to these broad powers is because they plainly were capable of being read in such a way as to allow the Secretary of State to do what they wanted to do. But then when one comes on to see the rules of interpretation that apply because it's a Henry VIII power, we see a narrowing of the focus. And we begin to see that set out.
So it is a very broad general power.
Indeed.
They can do it. They can make provision for services for any court tribunal.
Yes.
Any class of individual.
Seemingly a very open-ended, readily available power. And just for clarity's sake, at paragraph 15, we see where the Supreme Court confirms that it was indeed those powers that was being relied upon in answer to my Lord Justice Baker's question. It's 41A-B, 41.2A-B, 41.3B and C that they sought to rely upon.
Yeah.
So then we come on to the general principles established by PLP, which is generally, I think, fair to say, the leading case on Henry VIII powers. You can see at paragraph 22 onwards, there is a general discussion about the distinction between primary and secondary legislation. Entirely uncontentious, but effectively you can quash subordinate legislation even if you can't quash primary legislation.
What did Henry VIII have to do with it? Just out of interest.
Cromwell made great use of these Henry VIII powers to bypass Parliament. They might.
You always need to have your history in this court. As you observed last week.
I'm the dunce in the corner in that respect. So.
Thomas Cromwell.
Yes, indeed, Thomas Cromwell, of course.
Well,
I have only Hilary Mantel to thank for that. Nothing I learned at school I want to add.
I think. Well, it's a label given. It's a label given to the power because it's there, and it's quite a sense. I don't know who first adopted it.
No, I don't know.
Lord Judge adopted it in after, did he not? In various
it wouldn't surprise me if that was right, but I don't know if that's right.
But the basic idea, the reason why it has this tutor is it's perceived as being overreached by the executive in the way which happened 400 years ago.
Well, that's certainly one way of looking at it politically. I mean, from a legal perspective, it has certain implications. And those are the ones discussed by Lord Justice Moses about making sure Parliament can properly foresee how this is likely to be deployed. And then as we come on to see in this discussion by Lord Neuberger, there's some real meat in the bone of this.
Sorry, just a very small point. You said we're looking now at the leading case. Total obviously predates this case. You're not suggesting that we need to read Total differently in the light of the later guidance. In other words, you're not suggesting that it's out of step with...
no, my lady, I'm not.
Right.
And neither am I suggesting that Total was decided incorrectly. Well, it's certainly not. I'm not submitting you need to decide that Total was decided incorrectly.
No, I'm just trying to understand whether you think there's anything in Total's explanation of the principles or application that is out of step with the guidance we now have from the Supreme Court.
No, I don't.
Thank you.
Right, so where do we go to in the
So now on to general principle. He's talked about the distinction between primary and secondary legislation. Then at paragraph 25, we see a bit of the history, at least in terms of when a description is given as Henry VIII. And then the statement at the end of paragraph 25, second sentence, when a court is considering the validity of a statutory instrument made under Henry VIII power, its role in upholding parliamentary supremacy is particularly striking, as the statutory instrument will be purporting to vary primary legislation passed into law by Parliament. So these rules of interpretation are there to protect parliamentary supremacy. And because they are considered, and we'll see this language used elsewhere, somewhat exceptionally or supposed to be used exceptionally, there is very good reason for that. Then we come on to see paragraph 26, that the interpretation of the statutory provision conferring a power to make secondary legislation is, of course, to be effected in accordance with normal principles of statutory construction. However, in the case of an amendment that is permitted under Henry VIII power, to quote again from Craze, and I invite you to read that quote rather than me read it.
Okay. And do you want us to go on to read
Yes,
the citation from Lord Donaldson?
I'd be most grateful.
That's the rationale.
Yes, so
because whether it's negative or affirmative procedure, subordinate legislation is subject to less scrutiny.
Yes, it can't be amended. So you can't look to the secondary legislation as an indication of parliamentary intention. You have to look at the primary legislation and construe it in accordance with those principles. And the two principles I really would invite the court to have well in mind are: the broader the power, the more likely something is going to be within the literal meaning of the words, but not actually in contemplation of Parliament when setting down the enabling power.
Just say that again.
That the broader the enabling power, the more likely it is a purported deployment of that power will in fact be outside parliamentary contemplation when making the broad power.
That's a bit weird.
Yeah, that is.
I know that's what he said. But so if you're Parliament and you want to, I mean, it may be that this is the issue. If Parliament wanted to confer a wide Henry VIII power, it's sort of difficult to imagine how they could go about doing it other than by specifically identifying each and every way in which it could be done. You know, is that what's basically being said, that because this is exceptional, etc., etc., you really have to, almost like an American draft of a document, you've got to say, in particular, blah, 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 and do it that way.
My Lord, if I may say, it's a very astute question, but my answer to it is slightly different, which is to say, if you don't do that, then when it comes to the court's role of interpreting whether a particular deployment of a more generally expressed power is lawful, one might need to do a bit more work in order to establish whether or not it really was within the contemplation of Parliament at the time the enabling power was granted. And in some respects, this case is quite a good example of that.
You can, I suppose you can understand this in terms of trying to understand what the intention of Parliament is, in the sense that if you have a very broad or general set of words, it may be rather unclear what Parliament's intending to achieve.
Exactly.
Now, that may or may not be the case in relation to Section 124. That's what you'd have to convince us.
Well, my lady, it is my submission that 124 is expressed in broad terms. The specific provision that's being relied upon by HMRC is you can make provision about the circumstances. Absolutely no specificity about what type of circumstances, which obviously I will come back to.
Okay.
But we're in broad power territory here.
Yes, I mean, for my part, I'm happier with the proposition that my lady put to you.
Yes.
And I know Lord Newberger seems to have approved this, but I'm happier with what my lady put to you than the last sentence of the citation from Craze in paragraph 26, with which I share my lord's puzzlement about that. Why should it be that, maybe we don't need to worry about this. Why should it be that the wider, the more general the language, the more likely it is that this will mean the words will be outside the contemplation of the legislature? That is illogical, it seems to me.
Well,
yeah, anyway.
I understand that, because you've got a tension between what might be a legitimate desire to give breadth of power, to delegate breadth of power, but at the same time there is still going to be a sense of what you're trying to achieve here. Which domain are you in? What do you really have in mind? Which is a byword for parliamentary intention. But what I think it does do is at least two things, if I can put it this way. One, the mere fact you're within the literal words might not be enough.
Well,
Henry VIII power.
But that's a clear proposition, yeah.
And the second one is the scope to look to parliamentary intention as evidenced by other things, most likely other aspects of the Act, but also other materials, is likely to be more readily available, because you're trying to understand whether or not the particular deployment of the power really is within the contemplation of what Parliament had in mind.
On that subject, and before I forget to ask, I think we've seen cross-references to explanatory notes on section 124.
I do apologise.
Have we seen, or have I picked this up wrongly, cross-references to explanatory notes on section 124? I don't think they're in the bundle.
No. Nobody's thought to rely on explanatory notes for 124, in fact, but it's a good question.
But it's a highly pertinent question.
Yes.
I thought I'd seen something in the cases, but it must have been on other provisions.
There's nothing about there's nothing in Total about the explanatory notes in relation to 124, and of course Total is the only case before you that deals with 124.
But it doesn't mean it's not
relevant. It doesn't, no, and it may well be that for completeness we ought to ensure that that again is made available.
I think we should, yes, I think we should have them, even if just dismiss them from our inquiries.
I mean, I can understand, having just looked at it again, I mean, paragraph 27,
yeah,
Lord Donaldson's reasoning, I think, does give you perhaps more of an understanding as to what Craze says.
Yes.
If you assume that Henry VIII powers are an exceptional course for the legislature for Parliament to confer, even though they're widely used. I mean, again, it seems almost a little bit counterintuitive, but I think what you're saying is it's because of the particular nature of the delegation, that the delegator and delegatee in our constitutional system, that the courts have to be very sure that that is actually what Parliament intended, because of the risk of it not being.
Yes, exactly. Yeah. Exactly that. Obviously, you don't necessarily have to have the precise example set out in order to be a lawful deployment of Henry VIII's power, but you probably need to ask questions about whether or not a legislator is acting, whether the executive is acting in a way which is plainly within, if you like, the ordinary contemplation of the power as set out. That sounds a bit clumsy at the moment. I'm going to make it good when I come on to the facts of this case.
I just want to add, just for clarity, a reason I'm asking about explanatory notes is that Section 124 has general words, but they're not entirely in a vacuum. The heading of 124 is about reviews and appeals.
Yeah.
And I thought I'd seen, but maybe I hadn't, or maybe it's in the context of social security legislation, something by way of explanatory note explaining the purpose of introducing a review provision. Well, that's why I particularly would like to see those explanatory notes.
I mean, just to give you one brief example, in Total, one of the motivations for the order that was under consideration there was because I think there'd been a change in the correct tribunal for consideration of appeals. So that, for example, might dictate something about the circumstances in which an appeal needs to be exercised. Or you might have the sort of example that's given by Lord Justice Moses. I'm going to show you in due course, I hope, why the sort of condition precedent that we're concerned with is qualitatively different from the sort of condition precedent one might imagine Parliament had in mind when contemplating giving the power to the executive to put up condition precedents in advance of bringing an appeal.
Now, are you going to deal with anything else in Public Law Project? The application of principles, or not? We've got to the end of the citation from Lord Donaldson. Is where
yes.
Stopped.
So what the court goes on to do, basically, and we see this in paragraph 30 onwards in terms of Lord Justice Neuberger, is ask the question whether or not the deployment of the power in that case fell within the ordinary meaning of the enabling power. And in fact, the court decided that it did not, at least not naturally, and then had reliance on the fact that other indicators in the legislature suggested that the type of variation or omission of services that was contemplated by the executive was outside the powers of the enabling power, because there was no connection, I'm paraphrasing here, and in due course, if you feel it's necessary to do so, you can read this decision, but the essential reasoning was that the attempt to preclude anybody from abroad from applying for legal aid was ultra vires because there was no relationship between effectively where they came from and their need for legal services. And the conclusion was that the power should only be deployed to exempt certain people in a way which was connected to their need for legal services, which is what's set out in paragraph 31 and 32. And in particular, the last sentence of paragraph 32. But the main reason I'm taking to this case, if it's nothing else, is to say the point I made earlier, which is the mere fact it's within the literal meaning of the words of a general Henry VIII power doesn't necessarily answer the question.
Yes. All right.
So moving on then to fundamental rights, because just for completeness, of course, the right to legal aid is not a fundamental right. So the Supreme Court in PLP didn't have to engage with that question about whether or not this would constitute an interference with the fundamental rights of persons from abroad who are seeking legal aid. But let's then turn to fundamental rights cases. So this is Salim at tab 7, decision made in 2001. Tab 7. It begins at page 122 in the authorities bundle. Now, this is not the use of a Henry VIII power, to be clear, first. This is the ordinary deployment of secondary legislation or subsidiary legislation in pursuant to an ordinary enabling power. But it was about interferences with a fundamental right. And I think the easiest way to take you through this, if I may, is first of all, let's take you to the right of appeal that was at stake, which, if you turn to the very bottom of page 127 in the authorities bundle, unfortunately this doesn't really have paragraph numbers. You have that?
One, 2, 7.
Bottom of page 127, yes.
Yeah.
You can actually see, I find it easier to first read the right of appeal itself, which is in section 21 of the 1971 Act, which is then cited in full over the page on 128. So this is about an appeal from a special adjudicator to what was at the time the Immigration Appeal Tribunal. And then going back to page 127, we see the rule-making power contained in section 22 of the same Act. In particular, 22.1 subsection A, the Lord Chancellor may make rules in this Act referred to as rules of procedure. A, for regulating the exercise of the rights of appeal conferred by this part. So not quite the same language of circumstances in which, but not dissimilar, but not necessarily a lot right on that. But then when we've seen that, we see, well, how was this rule-making power in section 22.1a actually used in this case? And the first one we need to look at is Rule 13, which is at the, yes, on page 125. So it's the last full paragraph on that page. You'll see at the bottom of that paragraph, Rule 13.2 of the rules is cited, which imposes a 5-day time limit on an application to appeal from the special adjudicator to the IAT. Yeah. And then Rule 41 is the one that was in issue. Rule 41 is 125, bottom paragraph. Immediately under that, there is a power to extend, but only in the hands of the special adjudicator. And then the rule that was said to be ultra vires, section 22, is the rule at the top of page 126, Rule 42, in particular Rule 42.1a. Which was a deeming provision about service of these adjudicator's decision, which thereby triggered the 5-day time limit to appeal, and in particular those words, that it will be deemed to have been received on the second day after which it was sent, regardless of when or whether it was received. So then we turn to page 128. This is the judgment of Lord Justice Roche, if I'm pronouncing that correctly. And I'm inviting you to look at the paragraph that begins, an appeal to the Immigration Appeal Tribunal.
I want us to read that paragraph down to letter F.
Indeed, I'm most grateful.
Why don't you sit down while we do that?
Great.
Right.
So the 2 points that we need to take from that are, in the context of an appeal about an asylum decision to the Immigration Appeal Tribunal, it's a fundamental right, and it's the fundamental right of access to the court, and there's no difference to be drawn between the tribunal system and the courts of law in that regard, and that's been subsequently referred to in a positive sense by the Supreme Court, so we can accept that, that's correct. And then the implications of that.
And sorry, when you say it's been referred to by the Supreme Court positively, do you mean in the case you've taken us to on another case?
I'm coming to its unison.
Thank you.
Yeah. Apologies.
And then, yes.
So
the consequence.
the consequence is that
yes.
paragraph in E. If it is correct that Section 20 right is a fundamental right or basic right akin to the right of unimpeded access to court, then there is this consequence, that infringement of such a right must be either expressly authorised by Act of Parliament or arise by necessary implication from an Act of Parliament.
Right.
So once we're in fundamental rights territory, it's an even tighter test than the Henry VIII power test. Express authorisation, you can do precisely what it is you're purporting to do, or what you're purporting to do must arise by necessity. That's the test.
Yes. Right. I have an eye to the clock, Mr.
Yes, I
Burton,
I understand that.
So do we know, we're going now to the Supreme Court case you were referring to?
If
Or
I could just make sure, I just want to give you a couple more references for this decision because it is very important in the submissions. One moment. Just give me 1 moment to apologise.
Sorry, you're saying we want them to produce the bill.
There aren't any explanatory notes to the
What's the
earwigging. So sorry, but just to say, we've done the same check here. There are no explanatory notes to the Act. The explanatory notes are to the bill. They're 1,000 pages long.
We only need section
we just
124.
yes, it was clause 119 as was, and we're just pulling that out. Although it's not short, I think, and we need to look at it properly.
I mean, I'm off the top of my head, I'm wondering what weight can be attached to explanatory notes.
Well, there is some learning.
Bill, there will be learning, right? Yeah. I mean, it's an external.
Yes.
I'm thinking of Lord Hodge.
It's
Yeah,
mischief, I
Lord
think
Sales
we
has
would
said
say.
something even more recently than that. An explanatory note.
So is this the point you were making earlier?
Yeah,
The
yeah.
Post.
Yes, Lord Sales has said something, and I
Yeah,
can't remember the case. I need to check.
Post Hodge.
Yeah, he basically said you can always look at explanatory.
You always can.
Yeah.
Except
Oh, Lace Philip would say that. Yeah. There we are. Now.
Sorry. So if I could, this is actually the most important paragraph in the judgment. So
Okay, right. I'm glad we've.
Page 129.
You didn't let me push you on too much. 129.
Yeah, the first full paragraph.
It follows that infringement.
Indeed, my lord, yes.
Right.
Because I invite you to read that paragraph.
Yeah, well, that's.
But it actually goes on.
So it introduces a reasonableness hurdle.
Indeed. So even if you pass the by necessary implication test, there's then a reasonable test. Does the rule actually go further than it needs to in terms of the interference?
Well, I mean, that's not surprising in a sense, because even if you just go back to implication of terms, it's always said that to imply a term, it has to be reasonable.
Yes, indeed.
I mean, be careful, you don't imply a term because it's reasonable, but you don't imply an unreasonable term.
Yeah, my lord, exactly that. Yeah. And that's precisely what ultimately is decided in this case. And the question of necessary implication and reasonableness are treated separately by Lord Justice Roche at that point of the analysis. But when it comes to his conclusion, you'll see he effectively answers them in one and the same. That's at the bottom of page 130. And I then just wanted to take you to one part really of Lady Justice Hale's judgment. Again, just to assist with, for our purposes, in terms of the correct test and analysis. If you see the second paragraph of page 137, the first point I wanted to highlight, the more fundamental the right interfered with, and the more drastic the interference, the more difficult it is to read a general rule or regulation making powers authorising that interference.
Where are you reading from?
First full paragraph on page 137, my lords.
Right. Distracted by Lady Hale rejecting Mr Burnett's arguments. Yeah.
So that's, again, I'd say a general proposition, but the point I want to take from that is that the analysis of whether or not it arises by necessary implication or is otherwise unreasonable could potentially be approached effectively as the same question.
Yeah.
There will be an overlap. And my Lord Justice Snowden may have answered that in his observation about how you approach that exercise. So we don't need to get too fixated about the difference that might exist between those two questions, but they are an important part of the analysis. And then just finally on that case, there was a submission made, well, okay, I mean, this was a particularly harsh rule in the view of the Court of Appeal. It meant that somebody could lose their right of appeal without actually being given notification of that right of appeal because they might not have received it for any number of different reasons. The court said, well, that's obviously a pretty draconian rule and said it's outside the powers of Section 22. One of the arguments made was, well, it might only cause injustice to a small number of people. Most people are likely to be able to comply and do what's necessary. And that's addressed, indeed by the judge at first instance, but by Lord Justice Roche and Lady Justice Hale in the middle of that page paragraph C to D. The small risk of injustice to a small number of people has to be set against the overriding objective was a submission. And she said, I'm unable to accept that argument. The point is, it was deeply unfair to those who fell the wrong side of that rule. So moving on then from Salim, if we could then look at Unison, which is tab 20,
Right.
and go straight to paragraph 80 of that. My lady, I mentioned earlier that there was some sort of implicit approval of decision in Salim equating rights of appeal to the tribunal with the constitutional right of access to the courts. That's at paragraph 65, should you wish to have that reference.
Sorry, the paragraph you wanted to take us to was 80?
Indeed, my lady, yes.
So 65 for the reference
Yes.
mentioned, and then 80. So that, you say 65 approves Salim,
Indeed.
you say?
I don't believe it to be in dispute that the mere fact it's a tribunal as opposed to a court of law changes the fact it's a fundamental right that's engaged.
Okay.
And then at paragraph 80, this is really just now at Supreme Court level, approving the analysis that we've just seen in Salim about even if you're within the power, it still needs to be a reasonable exercise of that power.
Well, in fact, you only interpret the power to authorise the reasonable exercise of it.
Indeed, exactly.
So, in fact, although you put it in are you within it, is a restriction to reasonableness. In fact, he puts it in terms of interpreted as authorising only reasonable interest.
Indeed. There are indeed many different ways in which you can articulate perhaps the same point. And then finally, not quite finally, but very nearly finally on this case, paragraph 85, albeit in reference to a different case, but we can see it's applied by the Supreme Court in this case. When you're looking at the nature of the intrusion, you need to be considering it in the real world.
Lord Justice Dyson.
Indeed, my lord, yes.
Oh yes, this is about fees in care cases.
Indeed. And then again, just to make the point good, at paragraph 88, we see another iteration of the same point about even where primary legislation authorises the imposition of an intrusion on the right of access to justice, it is presumed to be subject to an implied limitation. And then in paragraph 89, draws together the obvious point that there is alignment between the requirements of Article 6 and the common law in terms of any intrusion with the right of access to the court being one which is proportionate and or reasonable. So, my lords, my lady, that deals with the cases dealing with fundamental rights. If I can then turn up CJ. Can I invite the court to read paragraphs 4 to 8? It sets the scene, and the point that will be made in court is that everything that's said in there effectively carries across to our situation.
Right, have a seat, Mr. Norton. We'll do that. 4 to 8 of CJ.
CJ, yes, beginning at page 512.
512.
512.
Okay.
So, pinch point is the loss of appeal rights
Yes.
to people who are outside their requests, and the qualitative difference about this rule is it renders the HMRC, or DWP in that case, HMRC in our case, the gatekeeper of the time limits. And that's the really important feature of this particular deployment of the power. At paragraph 24, there is references made to the purpose of the imposition of the mandatory reconsideration process. The broad purpose of the relevant provisions was to enable the Secretary of State to have the first opportunity to consider the correctness of the decision, including any new material which is often submitted on an appeal, and thereby prevent the need for the case to progress to appeal. And it's our submission that exactly the same purpose applies to the imposition of the mandatory review process in our context. There is a point at paragraph 26 about the tribunal's experience of how the pre-amendment process worked, which you may have picked up already from the papers, was an informal process whereby the DWP, and I think it's the same for HMRC, would treat an appeal as an opportunity to reconsider the underlying decision to see if it was necessary to change it in light of any new evidence that had come up in the context of the appeal. The appeal, of course, being a de novo hearing on the merits based on the evidence available at the time of the appeal hearing. The enabling power in primary legislation is set out in paragraph 27, and this is important for our case. So this is the primary legislation affording the Secretary of State the opportunity to make the rules in relation to the relationship between reviews and appeals, and it's subsection 3A, which is happily in bold at 517.
But that refers to revision under Section 9. That's not the same. That's the different revision process, isn't it?
My lady, slightly.
Because we're told that in paragraph 4. And what am I missing? That Section 9 previously existed.
My lady, yes. Yeah, sorry, just for clarity, there was always a right to ask for a mandatory reconsideration pursuant to
revision under
Section 9,
yeah.
or appeal. That was a freestanding.
But what you're telling us now is that is different to the HMRC rules, where there was no statutory mechanism for revision or review, as I understand it. So we've got a different architecture here. May or may not make a difference to the result, but it's a different starting point, statutory starting point.
Well, potentially. I can't at the moment think of any implications.
Okay,
from that.
but the so
there was certainly a practice of carrying out reviews when appeals were issued against HMRC
yes,
decisions.
but nothing in the statute. Whereas here, there's a statutory provision.
Can I invite my learned friends
yes, of course.
to just check that?
Yeah. Well, that's what that seems to say.
What is the same and was part of the same policy was the imposition of the requirement that you should seek a review before you can appeal.
Yes.
And the enabling power I was taking you to in Section 27, paragraph 27, apologies, is Section 12, subsection 3A, which of itself was an amendment introduced by the Welfare Reform Act 2012.
So 3A was introduced by primary legislation.
Indeed.
Shoehorned in, just as Charles put it.
So we haven't got the Henry VIII point.
No, we haven't. We've got the fundamental rights point, of course.
Yes.
The critical thing here to observe is that this was where the enabling power did seek to expressly authorise the restriction on a fundamental right.
So just going back, this applies to decisions to which Section 12 applies.
So, Social Security context, yes, but enacted by the 2012 Act in pursuant to the same policy, with the effect that the Secretary of State now had the power to do what's said in paragraph 3A, subsection 3A. Apologies.
And you make the point that it appears to restrict a right of appeal because it uses the term only if.
Yes, only if. It's certainly a condition precedent. It's a circumstance that must exist before a right of appeal can be exercised. A specific circumstance. Now, true it is that specific circumstance didn't have the effect contended for by the DWP in this case. The long and short of it is that when the tribunal carried out the exercise of statutory interpretation on the Salim test, it decided that it didn't go so far as to mean that an appellant, a would-be appellant, who missed the deadline for asking for a mandatory review and was not given an extension of time by the DWP would then lose their appeal rights. The way the tribunal approached that question was effectively to say, well, it's best I show you so you have the references. The issue is set out in paragraph 28. In a nutshell, what were the words the Secretary of State has considered whether to revise, limited to a situation where they'd actually revised a substantive decision, or where they'd decided whether or not to extend time to carry out a revision. Paragraph 28. And of course, that's a question of interpretation of the primary enabling power. Then at paragraph 29, for completeness, the secondary legislation is set out that purported to exercise that power. And we'll see the specific provision, 3ZA, Regulation 3ZA at page 520, again, usefully emphasised by the Tribunal. And there we see the utilisation of a condition precedent in exactly the same words as are used in the primary legislation. So when it comes to the test about fundamental rights, it passes because it's expressly authorised, but only authorised to the extent that those words permit. That became the subject matter of analysis by the Tribunal. But just before we move on to that, just again for completeness, you'll see at Regulation 4, page 521, that they reference to the late application for revision test that was imposed in the Social Security decision-making architecture, which is the same as the one that was imposed in the HMRC architecture. And we see those two limbs of that test at 521, highlighted again by the Tribunal, Regulation 4.4. Do you have that? An application with an extension of time shall not be granted?
Yes.
Grateful. Then just really probably for your pen, at paragraph 35, we see the introduction of the core point of contention between the parties, which you probably have by now. It's what did that mean? What did the statutory language mean in terms of what constituted a consideration of whether to review? And then the introduction of the important principles of statutory construction, paragraph 38. One is identify the mischief. And importantly, paragraph 40, we see the conclusion drawn having regard to the explanatory notes, which introduced the amendment.
Oh, that's what I'm thinking of.
Yeah.
These are explanatory notes to the 2012
Indeed, my lady.
legislation. Okay.
Inserting those explanatory notes at paragraph 488, they expressly identify
Exactly what we're trying to
point to the removal of right to appeal.
Yes.
Or there is to be no right to appeal in certain circumstances.
And then at paragraph 40, the justification was framed in terms of streamlining the appellate process and helping to get decisions right first time. There was not even the faintest hint of a suggestion in those notes that if a claimant was late in making a mandatory reconsideration request, but still within the further discretionary period in which the FDT might permit a late appeal, then the Secretary of State would effectively have the power to exclude the claimant's right of appeal on the merits to an independent tribunal, subject only to challenge by way of a claim for judicial review. So, on the tribunal's interpretation of the mischief, it didn't go so far as to require the right of appeal to be terminated once and for all if there had been a late request for a mandatory consideration. Then they go on to deal with the approach taken to primary legislation, which we can probably skip. But the conclusion is at paragraph 45 that there was nothing in the primary legislation that helped determine that question. And then at paragraph 46, they go on to consider the secondary legislation. But as we've already seen, it was expressed in precisely the same terms, so there was nothing to be gleaned from that. And then we see at paragraph 55 onwards the arguments, etc. And then at paragraph 59, what's effectively said there is, well, there's an ambiguity on the face of the primary, which allows us to have regards to other factors, principle of legality, because it engaged fundamental rights, and the scope of the enabling power, etc. The Secretary of State then made a number of points which are referenced in paragraph 60, which we don't need to concern ourselves about inherent risk and the degree to which this might go wrong and people might lose out on otherwise meritorious appeals as being a prerequisite to finding unlawfulness. And then the specific point is raised about Article 6, and in particular what's said there about there being a long-standing recognition, the one my learned friend referred to, that judicial review may be adequate even if the first instance decision or fact-finding decision is made by a body that doesn't meet the impartiality test.
Where are you looking at?
63.
Paragraph 60, F is where the submission is made, and then it's dealt with as my Lord Justice Baker says at paragraph 63.
Thank you.
Right.
So that just disposes of that point about JR as it's perceived by the tribunal. And I will come back to that in due course, but the important point to note about this is that the only circumstances in which the potential need to rely on JR in relation to a decision made by the DWP of a substantive kind arose in the context of official error. And it was said that in the case that's referred to in there, a decision by the Upper Tribunal, that satisfied Article 6, but that was partly because the underlying right of appeal wasn't extinguished. You could still challenge the assessment decision itself. And then we see at paragraph 65 the discussion about Salim, and it's all the passages that I've already taken you to. And then at paragraph 70 we start to see the beginning of the reasoning of the tribunal as to why they conclude that the primary legislation did not permit, and the secondary legislation did not in fact do, the thing that the DWP contended for. But in order to do that, there was a discussion about the relevant difference between the time limits. So if you're talking about the pre-amendment situation, it's the time limits available in the tribunal, which is the broad open-ended power, which we see discussed at paragraph 71 on to 73, an all circumstances type approach, then contrasted with the restricted approach contained within the regulations, which, as I said a moment ago, mirrors that which is introduced into our statutory scheme. And there's a specific discussion about where did the merits of the substantive request fall into that equation. Because you will have seen from the extension of time test, it requires there to be special circumstances which, as a result, mean it's not practicable for the application to be... it wasn't practical for the application for a mandatory reconsideration to be made in time. How does that relate to the question of any underlying merits? And it was said to be unclear. And then paragraph 77 is where we start to see the real reasoning. But it was important, obviously, from the tribunal's perspective, as it will be important for you to understand what this really means, because it's exactly the same in our context. If I could invite the court just to read paragraphs 78 through to 81, please.
Sit down, please.
apologise, it's probably sensible just for you to read all the way through to paragraph 88 now, because that contains the core reasoning. And 89, apologise. And probably 90, sorry. That will be it.
Right.
So, my lords and my lady, if I could just paraphrase that in one sentence, what effectively the tribunal is saying is the interpretation which says the words consider whether to revise the decision, which includes a decision not to extend time for a review, was the benign one because it had the best of both worlds. You could ensure that the purposes of the introduction of the MR procedure were met. You would require a request to be made. You would require the Secretary of State to consider it. But you wouldn't have the negative consequences of taking away appeal rights for people who had meritorious appeals but otherwise missed those time limits. And indeed, there was a second opportunity at the stage of the appeal for the decision maker to look at it once again if need be. So that was the essential conclusion of the tribunal, and it allowed the tribunal to say that its interpretation of the provision was consistent with Parliament's intention. That's the key point here. They weren't just saying it was preferable or better, they were saying this is what Parliament must have intended. There's no reason to take a different view. And the only part that appears to be potentially in dispute about how this carries over to our context is the reference of paragraph 83 to the reality is that many claimants will be vulnerable for reasons including issues relating to their mental health or learning disabilities. This being an ESA cohort, and as my learning friend pointed out, that doesn't necessarily, although it may, carry over to the HMRC tax credits cohort. But you do have the advantage in that regard of the recorder's adoption of similar observations in her context dealing with tax credit decisions.
So the passage that Mr Charles and colleagues, they're in this decision in 83 to 86, you say is mirrored to some extent in that passage in the Upper Tribunal.
Absolutely, yeah, she adopts it. She reaches her own conclusion, and of course it's a specialist tribunal, etc., etc. You know the position the appellate courts are.
So, to what extent does this impinge upon the argument that evidence is needed before we go any further?
Well, let me put it this way. You still got the judge's observations below, which we need to take into account. They are relevant to this extent to the Vari's argument that they may tip the balance one way or the other if we get to the reasonableness question. But I must stress that the submissions on behalf of the respondent is we get there anyway, even if you take out the potential negative implications, because you still don't need to interfere with anybody's rights in order to achieve the objectives of the legitimate aim. That's the key finding. That side of the equation is taken care of by an interpretation of the kind that the learned recorder found to be the correct one.
But you're not contending for that sort of interpretation. You're contending for crossing out section 38(1)(a).
Yes, I have to do
which
that.
has a different
outcome. Yeah.
As in no review.
We take that squarely on, absolutely. We have to. I mean, that's just the inevitable consequence of the way in which this is.
Yeah, but the outcome is different to the best of both worlds that you describe.
Indeed, it is. Indeed, that is undeniably true.
And how can you? And is it therefore consistent with Parliament's intention, which you prayed in aid as you identified as a key factor in the CJ decision?
Yeah. Well, the problem in my submission to HMRC here is when Parliament descends to the detail about this policy, it generates this rule. Now, it may be the Secretary of State, when trying to implement this policy, came up with a different rule, subsection 1A, but it doesn't really matter, frankly, what the Secretary of State thinks is the right rule. It's what Parliament thinks.
Well, you're saying that CJS effectively enunciates what Parliament intended.
Yes. Has to be.
And we have to read across because it's similar. It's
precisely the same architecture, really.
Well, okay, I mentioned at least one difference.
What differences may exist aren't such as to change the balance in our submission. And we also need to keep in mind, frankly, that in 2008, when enacting Section 124, there is no evidence as to what was in the mind of Parliament at that stage. So even if one was to, as it were, infer Parliament having the same intention in 2008 as it subsequently had in 2012 in relation to this policy question, it can't go any further, surely, than Parliament's intention in 2012. We can't imagine Parliament in 28 had a different type or a different approach to this.
Why not?
This is very difficult. The only way we can ascertain parliamentary intention is by looking at the words of the legislation, and that we're looking at a 2008 piece of legislation in a tax context.
Yes.
Because it's tax legislation, and you're saying it's exactly the same as Parliament in 2012 in relation to a different piece of legislation.
Yes, can I just elaborate on that? It's not necessarily exactly the same, but it can't go any further because you've got nothing to base that upon. So in 2008 we have a general power, condition precedent power, and that's granted to the appellant. Then we see, in pursuit of the same policy, we know it's the same policy because in 2014, when we see the explanatory memorandum for the order that imposes subsection 1A, it says to align the situation with the position with...
Okay, but as you've made very clear, your points are on section 124,
yes, I'm not
on the subsequent exercise or purported exercise of the power.
If I can put it this way then, the general power in section 124 is obviously more general than the power that was enacted into section 12 of the Social Security Act. But they both try to do the same thing, which is impose a condition precedent to the exercise of the right of appeal. And in that regard, one is obviously more specific than the other in terms of addressing the particular infringement we're concerned with. It's unrealistic to suggest otherwise.
So you're saying 2012 is more specific?
Yes, unquestionably. It is in fact a condition precedent addressing the very same policy imperatives, which doesn't go as far as that which subsection 1A seeks to do. So it contravenes, at the very least, Parliament's intention as it was understood in 2012. So it's difficult to see how the appellant can get over that by saying, well, actually, a completely different type of approach to rulemaking is contemplated when the general power was set out in 124. That's not my only submission about 124. I will come back to that. But it's a very important feature of this case in my submission. Can I just finish then by taking you quickly to Connor, and then I will wrap up. The Connor is tab 23, my lords and my lady. Now, Connor is decided after CJ, as we'll see. And Connor concerned a slightly different feature of the introduction of the mandatory reconsideration regime. So if I could invite you to turn up paragraph 16 at page 560.
Yes.
This is now speaking to the imposition of the condition precedent in terms of the mandatory reconsideration regime, as understood by CJ. So the right of appeal remains, but you might have to wait a bit longer for the mandatory reconsideration process to be undertaken. Even when described in that way, at paragraph 16, Mr Justice Swift accepts that that's an interference with the Article 6 rights. At paragraph 18, he says that may be so, but it's not an abrogation of those rights. It's certainly an impediment or a hindrance, paragraph 18 and 19. And if you look at the middle of paragraph 18, there it is said, third sentence, the Secretary of State now has the opportunity to revise her decision before proceeding in the first-tier tribunal, before proceedings in the first-tier tribunal can be commenced. But that does not give the Secretary of State any form of improper control over access to the tribunal. Of course, that's right, because on the basis of CJ, DWP is no longer gatekeeper. Whereas in our case, of course, HMRC remains gatekeeper if the appellant is right about the vires of the particular provision. Then at paragraph 19, even though the imposition of the MR procedure as defined by CJ isn't an abrogation, it's still an impediment or hindrance and therefore requires, it must be proportionate. Then at paragraph 20, reiteration of what the legitimate objective is of the introduction of the mandatory reconsideration regime. And we see reference there again to explanatory notes for section 102 of the 2012 Act. We see that 497 and 498 are the ones relied on by Mr Justice Swift, which is finished at the bottom of page 562 and over the page 563. Regulation 3ZA pursues the purpose referred to in paragraph 497 and 498, etc., and improving the effectiveness of the administrative decision making, so as to make more efficient use of resources, etc., etc. And then paragraph, he references that the bank mellet test is the correct test.
Yes.
And then paragraph 22 deals with what he describes as the second anomaly in this procedure. Actually, no, he's just there highlighting where it's introduced. My mistake, let me just get this right. 25, I'm most grateful to my learning. The two anomalies were identified. First at 25, the second at 26. And that is how he characterises the issue that was before the tribunal in the CJ. Cites the paragraphs I invited you to read 5 to 8, and then says what he says at the bottom of that page. In particular, that second sentence, the outcome. The Secretary of State has not assumed a role as gatekeeper for first-tier tribunal. It was clearly the preferable outcome.
However,
yeah, and that outcome was achieved by interpreting.
only achieved by strong purposes of approach.
Yes, seeking to identify what the mischief was and giving it an interpretation which was consistent with that mischief but didn't overreach by otherwise interfering too much with fundamental rights. The essence of the reason.
Right.
So, with all of that in mind, may I quickly return to the propositions and just give you the references if you want them and just make good a couple of points and then I'm finished. Is that permissible?
Yeah, well, it's at 3:45, so that is permissible.
I'm most grateful.
So just so I understand where you're going now to, with those references in our mind, you're taking us back, are you, to section 124?
I'm going to take you back to the 5 points that we made
Okay.
On virus, giving you specific references. And in my submission, if you follow the logic of these submissions, the conclusion is inevitable that this particular amendment was ultra virus. The first is, contrary to the Secretary of State's submission, plainly, Section 38 concerns a fundamental right of access to the tribunal. The judge herself said that below. We've got Salim at page 449.
So the judge said that UTJ.
Yeah, paragraph 29.
Salim,
it's page 449 of the report, but you might do better with the authorities bundle reference page 128. Endorsed in unison, paragraph 65, page 492. And Connor.
is that again the? Just so I know, that's the appeal, the bundle number, is it?
That's the. I will give you the paragraph number and the authorities bundle number, page
Thank
number.
you. Yes, unison you did. 492. Yep.
And in relation to same point, fundamental right, it's Connor, albeit that's first instance. I accept that, but it's specifically on point in terms of first-tier tribunal welfare benefits, paragraph 16. That's authorities bundle, page 560.
So if we're looking at the leading authority, it will be Lord Reed in unison at paragraph 65.
Yes, insofar as
approving Salim.
Yeah. And distinguishing, we say, Total, because in Total, the issue was very different. It was the loss of a right of appeal on a point of law on a discrete question about whether or not a condition precedent existed or not.
Okay, do you want to just take what specific paragraph in Total do you say was being distinguishable?
Well, it's paragraph 32 in Total, at paragraph 360, page 360, is where Lord Justice Moses said that case didn't concern fundamental rights.
Okay, all right. So it's the fundamental rights protocol.
Yeah.
So that which was the unsuccessful attempted buttress point.
Yes, exactly.
If I can put it in that inelegant way.
But it's relied on by my learned friends, meaning we're not dealing with fundamental rights here, which we say is an untenable submission. We clearly are dealing here with fundamental rights.
You're not saying Lord Justice Moses was wrong in that case, or that the court was wrong.
Distinguishing.
You're saying it's distinguishing.
Yeah.
Yes.
Plainly distinguishable.
Yeah. The nature of the right concerned.
Yeah.
Yes.
Submission 2 is that this the combined effect of section 38 subsection 1a with sections 21a and b is an interference with that fundamental right. Again, that must be incontrovertible. The judge found it paragraph 29, but we also take the reasoning from CJ paragraph 77 to 87, which is authorities bundle 536 to 8, and Connor paragraph 16 that we just looked at a moment ago, authorities bundle 560. And that was even without HMRC being or DWP being gatekeeper. So it's clearly an infringement. But when HMRC is gatekeeper, it's a more serious infringement.
Is this point 3 or
It's still point 2.
2A?
But the consequence of it being an infringement of fundamental right is, Salim, it follows that an infringement of such a right must be either expressly authorised by a provision in an Act of Parliament or arise by necessary implication of an Act of Parliament. Again, Salim, page 449. Authorities bundle 128. We say paragraph 3, the interference is plainly not expressly authorised by an Act of Parliament. That must be incontrovertible.
So you say it's not authorised?
No. Not expressly authorised.
Not expressly authorised, right?
So there...
It turns on necessary implication then.
Yeah. Contrast CJ where it was expressly authorised, albeit not in the manner that the DWP at least contended for. Then submission 4, applying the strict approach necessary, neither does the interference arise...
Sorry, you're going to have to go slow
I'm so
if you
sorry.
want me to take...
So just to go back on the third. The third
So-
was it's not expressly authorised by the Act, i.e.
Yeah.
section 124.
And I was contrasting that with the situation in CJ,
CFCJ.
where it was expressly authorised.
Right.
Albeit
And
not
then
on-
applying the strict interpretation required of a clause of this sort of the fundamental
Yeah.
law.
So
I'm getting there.
that means on to 4.
Yep.
So it's either expressly authorised, which it isn't, or it arises by necessary implication of section 124. But if it doesn't, then it's ultra vires. We say it doesn't, and I make the following 4 points on that.
This is the key point of the case on your case, isn't it, really?
It's certainly most of the key points.
Yes.
The first is that it's not enough that subsection 1A is a condition precedent and section 124 2A subsection 2 permits condition precedents. That's the literal meaning submission. That's only the beginning of the discussion, not the end of it.
Right. Slow down, please. Literal is not enough.
Literal is not enough.
Yeah.
We see that from Total and from PLP.
All right. Yes.
And the second point is a condition precedent, the existence of which is contingent upon a decision by the HMRC, is one we say is outside the ordinary contemplation of section 124 2A2. We make that submission for this reason.
Section 1242A2.
Which I have called the condition precedent power, in order to paraphrase. Condition precedents to the rights of appeal are ordinarily of a kind that it's the tribunal itself that can determine whether or not those condition precedents exist or not. It's fanciful to suggest, 2008, that Parliament could have imagined the use of this power to introduce a condition precedent, the existence of which is contingent upon the HMRC, the would-be respondent to an appeal.
A party,
Yes. A party would suffice. It's so out of the ordinary for the sorts of things that are imposed as condition precedents on the exercise of a right of appeal. See Total. There's no question of the HMRC having the final word on whether or not tax has to be paid, or indeed whether or not it would cause hardship if it was paid. Completely different type of approach, completely different type of condition precedent. We test that with a really easy example. Let's say there was a time limit, but whether or not the party had met the time limit was completely within the control of the other party. Qualitatively different, highly unlikely to being within contemplation when section 124, subsection 2, subsection A, subsection 2 was enacted. You would really need to find something to help in our submission, in the legislation itself, to support a contention that such a condition precedent, which did make HMRC the gatekeeper, was remotely within the contemplation of Parliament in 2008. And this is where we say, third point, that this case is a for sure CJ. Because even when Parliament did descend to the detail, by enacting through the Welfare Reform Act, Section 12, subsection 3A, Social Security Act, it did not do so in such a way as to mean the right of appeal was lost if somebody made a late application for a review.
All right, just a moment.
So when you say a fortiori, it's because there was primary legislation. You're making the case there was primary legislation and more specific.
Expressed
it's the 2 points, really.
Yeah, the two married together.
when Parliament itself descended to detail, it did, point one.
Yeah.
Point two, it didn't do so in a way which
The Secretary of State
deprived the party of the right of appeal.
That's the decision in CJ. So either CJ is wrongly decided, or Our case is A for sure ICJ.
All right.
And you will remember that a key component of the reasoning in CJ, of course, is that DWP is rendered gatekeeper. And that was the part of the proposition in CJ that ultimately wasn't accepted. So it marries with my second point, which is it's not an ordinary deployment of a condition precedent power to take that away from the tribunal itself. The tribunal can't decide if an application for a mandatory reconsideration has been made in time or whether time should be extended. It has no role to play in the existence or otherwise of the condition precedent to the right of appeal. That is what's so qualitatively different. That's what we say was outside the contemplation of Parliament when it enacted section 124 and A for sure ICJ on that point. So, in light of that, we say there's nothing in section 124 that makes the provision as set out in subsection 1A and the restriction of fundamental rights that follows necessary, either because, now reading from Lord Justice Roche in Salim, because the purpose of Parliament cannot be achieved without it, or the function of Parliament is laid on a personal body, or the function of Parliament that has been laid on a personal body cannot be discharged without it. It's just not necessary to go that far in order to exercise the power contained in section 1.
Your second point is the function conferred on a body,
yes,
can't be exercised without it.
Yes. So that's where the necessity aspect of the by necessary implication component.
Okay, subject to the point that the effect of your submissions is to remove that right of review.
I absolutely accept that. Yeah, and I'm not.
Just for my note, do you have the particular reference to where Justice Roche says that in Salim? You took us to it earlier, but
I do. It was the paragraph on page 129.
It's not. This is the judgment that's not numbered. Paragraph numbered.
Yeah, it's not numbered, unfortunately. No, it's the one I almost missed out.
thank you.
Because I was rushing you on.
That does it. Thank you.
Thank you. So the final point, which is again maybe part of the mix of the fourth point, is that even if you accept it's a lawful. Even if it's a purported lawful use of the power in the sense that it arises by necessary implication, on the basis of Salim and indeed Supreme Court in unison, it's nevertheless unreasonable because it goes further than is necessary to achieve a legitimate aim.
This is your fourth. What is this? Your fifth?
That is actually the fifth point, yeah. But the fourth and fifth are often addressed in the same way as Lady Justice said.
I'm referring to which cases they're unreasonable.
So in that regard, we adopt the reasoning in CJ, in particular the conclusion that paragraphs 88 to 90, where it's basically said that if the end result is that those who are out of time to request their mandatory reviews lose their right of appeal altogether, that frustrates, in fact, the legitimate aim, which is otherwise met perfectly adequately by simply requiring there to be an application before an appeal can be brought. So this is overreach.
Yeah.
And that's why it's unreasonable. Exactly in the same way as it's Salim, although it's a different type of rule, it was overreach. It was legitimate, of course, to have a tight limitation period for appealing. It was also legitimate to have some deeming provisions about notice, but just not those particular deeming provisions. They went too far in terms of the level of intrusion with the fundamental rights, and we say the same applies here. But keep in mind how Mr Justice Swift paraphrased the issue in Connor, which was to say it was an unintended consequence and it was clearly preferable for DWP not to be gatekeeper. We say exactly the same here. So we say even if you say it arises by necessary implication, which we say is not possible, it's still an unreasonable use of the power. That is the same submission we make on Article 6. Moving on to Article 6 now. It's basically identical to the fifth point. So even if you're not with the respondent and you believe Parliament did in fact, by necessary implication, empower the Secretary of State to make this rule, we say it's nevertheless a disproportionate interference with the respondent's Article 6.
So as you've argued it this afternoon, and maybe it's always clear, your Article 6 point only really arises if you are unsuccessful on 1 to 4 of ultra vires.
Absolutely, subject to one point I'm going to make about relief in a moment, but yes.
Okay.
My second point on Article 6, just so you have the reference, is that judicial review is not an adequate remedy, except we're talking about judicial review of the Section 21B decision. There is no right to review the substantive decision, as my Lord Justice Snowden observed. That must be correct. You'd be knocked out as an abuse of process. Insofar as you can judicially review the Section 21B decision, the Secretary of State overstates the position. See right tab 26, paragraph 23, insofar as the Secretary of State maintains that unless it's an issue of fact that has to be determined, judicial review is always adequate. That's incorrect. One must also have regard to the existence of safeguards, if any, at the first instance decision-making process, i.e. in our context, the Section 21B process. And that is to be contrasted sharply with the decision that you have in the bundle, which is Ali versus UK, tab 29, which concerned homelessness review decisions, which also act like condition precedents to the right of appeal. I'm going to give you the references.
Are they flagged?
They are. They're red flagged. It's page 679 of the court's bundle. Authorities bundle.
74 onwards.
Yeah, exactly.
7485.
And effectively, just in a nutshell, the point there, if you can read it, is there are all sorts of safeguards attendant to the review process in the context of Housing Act appeals. Has to be by a superior officer. You have right to make representations. You have a right to be given a minded to letter if they're minded to find against you.
Yes.
There's all sorts of evidence gathering processes. There is none of that here. We've seen it actually be deployed. My learned friend says, well, there were problems in this particular decision. That's as may be, but there is no process hereby in the statute, at least, or in the rules, which says there should be some exchange of evidence, there should be an opportunity to make representations. So you don't need to constrain yourself to the facts of this particular case to see that there is nothing like the procedural safeguards here as there are in Begum, which make the process of a limited right of appeal, it's a right of appeal in that case, not a judicial review, consistent with Article 6. So that's our backup position on Article 6.
Right.
Remedy, just a very simple point. If you are with the respondent that this is ultra vires, it's true that unfortunately subsection 1A has to go in its entirety. It just couldn't be done.
You mean a declaration of incompatibility? No, what do you mean? You mean struck? What do you mean? You mean struck out as ultra vires?
So that removes the review process, reconsideration.
It doesn't remove it doesn't remove it at all. It still carries on. It just doesn't make the right of appeal contingent upon there being a request. You still have a mandatory obligation to carry out a review if one is asked for. You still can ask for one. All the Section 21A and B structure all remains.
What goes then?
The contingent point that you can't appeal until such time as there has been a review decision. You can appeal in theory beforehand. But we're not here to remodel the legislation in a lawful way. This is the way it's been attempted, and on our submission it's ultra vires. We are stuck with that fact, subject to my caveat, which is if we find ourselves in that place, you could deploy, if you were to take the view you can't grant a remedy here or for some reason it's inappropriate, you could deploy a declaration under Section 4 to achieve the same outcome. You actually could probably just do it by declaration on ordinary principles and then leave it for the tribunals to work out what to do. There are a number of different ways.
You mean a declaration of incompatibility?
Yes,
we
so
don't get that far if you succeed
on ultra vires.
So, if we succeed on ultra vires, then in principle, there's no power to do this at all. One way of addressing that would be to make a declaration which says it's ultra vires to this extent.
What extent?
To the extent that it means a person who's made a late request for a review and time is not extended in relation to it can still appeal.
Well,
that would be the CJ outcome. It's difficult.
Well, you say it's difficult, but I think we need to focus on this, and I don't want to rush you. I do want to rush you, but I want you to focus on it, please. How would you express that qualified strike, that qualified ultra vires?
We would say that the 2014 order was ultra vires to the extent that it introduced a provision in the form of Section 38, subsection 1A, which had the effect that somebody who made a late request for a review in respect of which time is not extended has lost their right of appeal to the first tier tribunal within 13 months. You have a broad discretion in relation to remedy. That would be one way of addressing the overreach problem.
Well, can you point to an example of a provision being declared ultra vires in that sort of limited way?
My understanding is, but I will check this if I may, in Total I think they simply declared the purported amendment to be unlawful by way of declaration.
Should we look at that, see what the decision was?
I believe that's right.
21, is it?
Yeah.
Okay.
No, 20.
This is a declaration under the Court's general powers.
Yes.
I was confused by your reference.
Yes, I'm terribly sorry. I was rushing and I confused everybody.
Okay.
So this is general powers, utilised, as I understand it.
14.
I mean, it's the closest we really
Well,
get.
I mean, I'm looking at what the end of the end of the judgment, 362.
Yeah.
Under Lord Newberger's consenting judgment.
Yes.
Well,
The
I think
paragraph
it's just finding that it's ultra vires. It's not.
I agree.
Insofar
It's
as
not
it's-
crystal clear.
Does he refer to it in the?
I think they didn't need to go further in that case because all they were doing was removing the apparent prohibition on appeal to the upper tribunal.
Yes, but
just
they-
reinstated.
That's right. So you can.
So that isn't the answer to my question, is it? An example of an ultra vires declaration to the limited extent you're proposing.
No, it may not be. I mean, could put it this way: that the court could order the tribunal to disapply the amendment to the extent that it prevents somebody from appealing in the circumstances we're concerned with. I mean, obviously, the remedies available to this court are wide and discretionary. I don't believe it's beyond the wit of those at the bar. I hope not to come up with a sensible proposal if we get.
I mean, the one thing we've got to be careful. I'm sorry, of the law of unintended consequences and striking down things which have a deleterious effect on the workings of the system more broader than are necessary.
So, indeed, but can I make just two very quick observations about that? One, the tail cannot wag the dog here. If it's ultra vires, it's ultra vires. We can't avoid that consequence.
Well, that's a different point.
Well, it is, but it's
The
very
point.
important.
The point. If it's ultra vires, it is. If it's ultra vires in the specific way which you assert, then it's that part of it which must be struck down, quashed, not the whole. If we can do so, not the whole provision, which could have consequences that have we've not been addressed about.
So, sorry, can I just try and, again, I was always behind the curve, but as I understand it, section 38(1)A, and indeed the words in square brackets in section 38(1) were inserted by a particular statutory instrument.
Yes, we can look at that.
In 2014.
Yeah.
In the same way as in Total, a particular statutory instrument inserted section 84(3)(c).
My lord, yes.
And what they did in Total was to simply declare that the insertion of 84(3)(c) by the statutory instrument was ultra vires, and then, if the report is correct, quashed it. As I understand it, you say we could do the same.
Oh, absolutely.
And if you just took out, if you just made that declaration in effect, you just reversed the change that was made in 2014.
Yeah, but it's more radical in its consequence.
Well, but in terms of a matter of technique,
Yes.
but you also say that if you just take out 38(1)A, that doesn't in any way remove the right of people to ask for a review, or indeed the obligation for the revenue to conduct a review under 21A.
Absolutely not.
It just stops it. It just stops the. Or it prevents the failure for asking for it within time from acting as a bar to an appeal.
Yeah. So, my lord, our primary position.
So we just go back to the position as was before 2014.
Exactly.
There's nothing. You say people.
With the
the
slight
world didn't
improvement.
stop in 2014, or before 2014. So we're just going back to the pre-2014 position.
Yes, there's no, to use the pejorative term, chaos as a consequence of this. We do just revert back with the added benefit that Section 21A and B still exist, as my lord refers to, but we just have done away with the condition precedent. What I was trying to indicate was that if the court was minded to try and find a more satisfactory way to basically align the position here with the position in CJ, which is what the learned recorder purported to do, it may be possible for us to do that by way of crafting a declaration that achieves that outcome. But it's not obvious to me that that's been done in another case, but it's not equally not obvious to me that it can't be done. It seemed to me any obvious obstacle to that.
Actually, I'm not sure I'm quite right in what I've said to you, because the 21A was also brought in.
Yeah.
So
Can I
in fact,
tell you
we
that
wouldn't be going back to a pre-2014 position. We'd be going back to some part of the 2014.
Well, I'm not sure that's right. If we could turn up page 82 of the authorities bundle, please. This is the secondary legislation purporting to introduce the amendment to Section 38. And we're here concerned with Article 2(6), paragraph 11.
Yep.
We could just say that that was unlawful.
Actually, it's just paragraph 2, subsection 11.
Yeah. So we could be quite surgical about it in that regard.
Actually, 10 and 11.
Well, what do you then do to deal with the situation where a review is requested, and you would then want the legislation to work that the appeal is against the result of that reconsidered decision? Haven't you just removed that?
My lady, there's never a right of appeal to the mandatory reconsideration decision.
You do you not appeal against the conclusion of the review?
No. I'm terribly sorry if that point has been missed, but absolutely not. No, you appeal against the underlying initial decision. Always. That's why.
No, there's. Can you look at 1C, please, on page 82?
Which is on page 58.
1C.
Well, 1C in the order it's on 82, and as 38 was amended, it's on page 58.
My point is that if the review, reconsideration, whatever it is, produces something different, then the appeal should be against that.
Yeah.
And you've just removed that from your approach. And it also has an impact on time limits, I expect.
So you just need to take out 1A.
Yes.
You just, it's going back to what I think I said a little bit ago, but forget the bit about pre-2014. You take out the square brackets, the words in square brackets in 38(1),
Yes.
i.e. the words subject to subsection 1, capital A,
Yes.
and then you take out 1A.
Yes.
But as my lady said, you must leave 1B and 1C to allow for an appeal, against a varied decision.
Through the MR process.
Yes, that's right. But that would work because the appeals still stand. I mean, the appeal is still there. So, but you can't take out 1B and 1C, and therefore you can't strike down in quite the same way, but you just take out.
Yes.
Now, well, do you respond to that, and then I'm going to. Yeah.
Well, I agree with my Lord's observations, and it is a slightly more surgical exercise. It's not a blanket removal of the order, for example, and I'm sure we could get there in a way which does its best to honour the provisions which are vires and take out those which are ultra vires.
Now, what I'm going to propose now, unless you have anything else you want to say, any questions? Anything else? Thank you very much. I'm going to propose that we hear from Ms. Smythe in reply, and then we will rise briefly to consider whether there's anything else we want to say to the pair of you, all of you, about how we will proceed in the event, heavily underlined, in the event that we were with Mr. Burton on ultra vires. But let's not jump that fence yet. Let's hear your reply, Ms. Smythe.
Yes, my lord, I'd certainly invite the court not to be with Mr Burton on that point, because I say he's simply wrong about it. Can I take things in 4 parts? I see the time.
Yes.
I'll be as quick
No,
as
no.
I
Well,
can.
Ms. Smythe, you must have as long as you need. We can consider it later. You must have as long as you need, within reason, obviously. We'd like to finish this afternoon.
Of course, yes.
Mr. Burton has been at least twice as long as he said he was going to be.
Yes.
And that's no doubt my fault for not keeping him under control. But Ms. Smythe, you're certainly not going to be at any disadvantage, or your team generally. Yes.
I'm very grateful. So the 4 things I need to deal with. First is an issue from my submissions, which is to do with process and this particular case. Second, a minor point on a point that was made about Mr Burton to do with what the judge must have meant in relation to how things should be dealt with at first tier level. Third, then, I obviously need to deal with ultra vires. And then finally, a very quick point on Article 6. So can I start with the process point?
Yes.
And the court very rightly raised concerns in the course of my submissions, and I should say at the outset that those instructing me agree with those concerns, and indeed did before this hearing. And can I emphasise again that senior people are aware of this case, and in fact feedback has already been given before we came this morning to operational teams and those who deal with training. The point that I should also add, in fact, is the process has changed since this case was dealt with. What happens now is that the mandatory review process is conducted by specialised officials who sit in the legal operational teams. And that, in part, was done to improve decision-making on these kinds of decisions. So those instruct me have absolutely heard what has been said. The other points I need to make is this. So far as the call is concerned, what we said in our skeleton, and this was not well expressed, and that's my fault, is that HMRC understood that he was self-employed. We don't take the view that that was a reasonable position necessarily for the person on the call to take. What the position is that once it became clear that there was a language issue and that he couldn't understand, that with hindsight he should have been referred to something called the Needs Enhanced Support Service, which allows somebody to assist with translation issues. But I should make clear that certainly it hasn't been my view, and indeed those sitting behind me, that call, that the information that was drawn from the call was reasonable. The real issue, so far as his conduct is concerned, and I do need to repeat this, is in relation to the Section 17 notice. Now, I do know that point didn't find a great deal of sympathy with the court, but I do need to say on HMRC's behalf that Section 17 notice is a really crucial stage of the process, because it
just refer to yourself and those sitting behind you. I don't think, certainly speaking for myself, I was suggesting that the Section 17, Section 18 letter isn't important and that somebody shouldn't have responded to it if they saw it was wrong. What I think I was, for myself, jibbing at a little bit, is that I think you at one point suggested that was that it was all, as it were, Mr Arrbab's mistake, and that no previous mistake had been made.
No, and that's not the case. It's a combination of unfortunate circumstances. It's just from our perspective to emphasise that is important, and I've taken instructions. It's the reason why there would not be accepted in this case to be an official error. And I'm told that there is case law at Upper Tribunal level which deals with whether there can be an official error in circumstances where somebody has contributed to the problem by not responding to a Section 17 notice. And for the court's purposes, there won't be an official error if there's been some material contribution to the issue by the claimant. So that's why we get to where we get to in this case. But we certainly don't say that that call progressed as it should have done. Absolutely not. So
well, you have our point also,
yeah,
our concern that we're even more concerned about the fact that, what is it, over 4 years, 4.5 years since
yes.
the call. And it wasn't only last Thursday when we received your skeleton argument that we realised that the concession was now being made. Anyway,
yes.
I think we've covered that ground.
Yes, and
we're grateful to you for, and those who sit behind you for, reassuring us about the changing practice which
yes.
is taking place. Yes. Now
yes,
you want to go on to
right, the minor point. I'm not sure that anything turned on this, but I perhaps better clear it up. That Mr Burton said what the Upper Tribunal judge must have meant was that the Upper Tribunal should extend time for the appeal to be heard. She can't, in our submission, have meant that.
This is paragraph 2.
Yes, it's for the reason we give in paragraph 4.2 of our supplementary skeleton and footnote 3, which is that on the basis of the Upper Tribunal's decision, the kick-off point for the appeal is the July 2019 decision, and the appeal is then brought within 2 weeks. So there's no need for any extension of time of the appeal. As I say, it's footnote 3 of the supplementary skeleton, which gives the date. Either the judge missed that point, or, as we surmise, can only have intended that the first tier carry out the Section 21B decision.
Okay.
Okay, footnote 3, 4.2.
Footnote 3, 4.2,
Thank
yes.
you.
So that brings me to the ultra vires point. Can I just make a headline point here, which is an important point? And it's this, that what is being challenged as ultra vires in Section 38(1)(a) is the very thing that my learned friend says was Parliament's purpose, which is to ensure that there was consideration of the decision before an appeal. So the provision that he invites this court effectively to wipe out is Section 31A. And Section 31A says, before you can appeal, you need to have requested and had a decision on a mandatory reconsideration. And that's why we have been at pains in our skeleton and also in my oral submissions to say, well hold on a minute, what is it that's being said to be ultra vires?
That's what's been exercising us in the last 20 minutes.
Indeed, but it's a good reason why my learned friend's submission is wrong. What he's trying to do is essentially bring in a whole set of legal principles to try and strike down this provision, but they are not correct submissions to make if what he's saying is Section 38(1)(a) is ultra vires, because to the extent that he's saying all this is all interference with a fundamental right, so the court has to disregard, strike out in effect Section 38(1)(a). Section 38(1)(a) is inoffensive. Indeed, it does exactly what the court said in CJ was the purpose.
Well, what he says is it goes too far. It includes something which includes something which is out with the power granted by Parliament.
With respect, what it does is say what you have to do before you can appeal is apply for a review and have a decision. That's all it says.
But what I thought, I think maybe I misunderstood, but I thought that what he's really saying is it gives the opportunity, that the purpose of the introduction of these provisions is to give the opportunity for HMRC to conduct a review before there's an appeal and for the person to request that. But it goes too far to say that if you don't, you should lose the right to appeal altogether. In other words, it's not necessary to streamline the process. But if you look at the earlier case law and indeed some of the explanatory notes, they're saying for good decision-making purposes, you should give HMRC, or the authority, let's call them anyway, because it's not always you, the opportunity to have another look at its decision rather than to have to engage in an appeal.
Yes.
Is your point that the interpretation being put forward makes this one-sided? It would give the claimant the ability to ask for a review because 21A and 21B would still be there, but there would be nothing to allow HMRC to insist on a review.
Yes, And that undermines the whole thing, because in the social security space, there was always the opportunity to ask for review. Indeed, CJ sets that out. But what they say is the changes were made because the purpose is to make sure that it happens before the appeal comes. And you weren't taken to the passage in Mr Justice Swift's decision where he says exactly this.
I think I was trying to make this point earlier. That Section 9 in the Social Security rules had a provision for a review in any event, pre-existing. There was no such provision in the text.
Yes, that reviews, I'm told reviews could happen. I think that there are several different points here, all colliding. I think there's a reason in my submission that Section 12 is worded differently, because it's different from Section 124. But the point really, and I think the best way to do it is to invite the court to turn up Mr Justice Swift's decision at tab 23, is at paragraph 29, and Regulation 3ZA, this court will recall, is the provision that says you have to consider whether to revise. You can't bring an appeal unless the Secretary of State has considered whether to revise. Can I just ask the court to read
Paragraph 29 on
29
page 566.
Yes, 29 to 31, please. So what Mr Justice Swift is saying is, no, the opportunity for review is not the point. The point is you've got to mandate it. And we've seen in CJ that that's a point that's made by the Upper Tribunal. What the kernel of the argument is, and the result of it is, no, you strike down Section 31A as ultra vires, despite it reflecting the very purpose of ensuring that there is a review of a decision before an appeal.
Yeah, I mean, I think it goes back to paragraphs 497 and 498 of the explanatory notes, doesn't it, which are at page 561 and 562. I mean, the concern is just that in practice, people weren't asking for a review and making an appeal from the outset.
So it needs to be given,
where are you?
Needs to be given some teeth.
In the explanatory notes to the bill, presumably.
But it seems to be, bearing in mind those are that's the Social Security.
Yeah, but sorry, that's the explanation. Sorry, the what lies behind paragraph 29 that you took us to, I think, is what's said at paragraph 20 at 561 to 562 in the explanatory notes.
And that the court does have the explanatory memorandum to the 2014 order at tab 32, page 726. And paragraphs 7.1 and 7.2 explain what's being done and why.
Okay, but you are going to provide the explanatory notes for the...
Yes, we are. Yes, we'll extract the relevant bit. So my point is, in a nutshell, is one can't have this patchwork of all of these different points. One's got to look at, one, what's being said to be ultra vires, and two, why. And the headline point is, it's said to be ultra vires to require somebody to apply for mandatory reconsideration before they appeal. But that was the very point, as explained in CJ, and indeed by Mr Justice Swift, of introducing the requirement. So what this court is being asked to do is disapply a perfectly sensible requirement to apply for mandatory reconsideration before the appeal. And it doesn't do then to start bringing in sections 21A and in particular section 21B, because those are plainly within the vires of section 1241, because they make provision for and in connection with reviews. So it is a patchwork of various things that don't hang together. So that's my headline response to it. can I then just make some points on the various authorities that have been referred to?
So you're saying no argument that 21A and B are within virus. That is part of an essential patchwork. You say they don't work. Can I put it this way? You would say 21A and B don't really work to achieve the purpose without 38(1)A.
Yes.
They have no teeth, I think was the expression you used.
That there needs to be teeth, and Section 31A essentially is introducing a new requirement to ensure somebody requests this review before they appeal, precisely so that the tribunal system is protected from bad decision making. And without teeth, it doesn't happen. Now, there is in my submission nothing about that which is objectionable. The real objections are coming, as I anticipated, in relation to Section 21A and Section 21B, but they are, in my submission, clearly intra-vires.
Well, that isn't how Mr Burton put it.
Well,
Mr Burton put it on the basis of very, very clear that it wasn't. He didn't talk about Section 21A or B at all.
Well, he may not have talked about them, but the target of his submissions was what they say. He doesn't talk about them because it doesn't suit his case.
Well,
but the target of them in my submission is Section 21B, which is the provision that sets out the conditions before HMRC can admit a late request.
You would say the proof of the pudding is that discussion we had for the last few minutes about how you actually would address this if we were with Mr Burton.
Yes, what will happen is that you strike down as ultra-vires a perfectly reasonable requirement in Section 38(1)A that before somebody appeals, they request and get a decision on a review.
Well, I mean, it depends what your point of view is. I mean, it doesn't say that somebody can't request a review. They can request a review under 21A. It just means that 38(1)A doesn't. There's no teeth, so that you potentially get to the problem identified of the same type that was identified in 497 of the explanatory notes in Connor.
Yes.
That we looked at. You know, you potentially get to the problem that people just don't make use of the review mechanism, but just go straight to an appeal. That's the problem from your point of view. In other words, that the review system has no teeth in it.
Yes, although
and the other side it said, well, okay, but the teeth are beyond what's reasonably necessary to achieve the purpose of having a review system.
But the teeth that my learned friend seeks to extract are teeth which simply say you have to ask for a review and get the outcome of it before you can appeal. They don't do any more than that. But I don't want to go around in
he
circles.
isn't seeking to. Well, he would say he's not seeking to extract those teeth. He's seeking to deal with a different infection.
Well, then the different infection is intra-vires for the reason I've submitted. So can I just deal with this point about, well, it's a necessary implication case. No, it's not in my submission. As my lady pointed out in oral argument, each ultra-vires decision that a court makes turns on the terms of the legislation at issue. So one can't extract principles from cases looking at different statutory provisions which concern whether or not something is within the scope of a power, principles applicable to this case. I come back...
So, say that again? You can't extrapolate.
So,
you can't... Or was it extract?
Yes.
Extract, you said, principles. Well, you're saying that the principles on the authorities in other provisions don't apply.
Because ultra-vires is not the same as Article 6, although it's being conflated to some extent. Ultra-vires is this exercise of a power within the scope of the enabling power, and that is fundamentally an exercise in statutory construction. It requires the court to look at the enabling power. So if, for example, and I will take the court, or give the court the references in Salim, the court decides that, and I'll come back to this, that it's ultra-vires to do X because it's not within the scope of a provision which says you may make rules for regulating the exercise of right of appeal. That doesn't help this court in my submission on the proper statutory construction of section 124. So what one has to do is go back to section 124, and we say this is not a necessary implication case, it's a clear powers case. Could I just, I'm afraid, ask the court to turn back to section 124?
Yes.
And any statutory provision that the case law is clear has to be construed in context. The context of section 124 is different from the context of section 12 of the Social Security Act. A key reason for that is this is a provision which is expressly providing in 1241A for and in connection with reviews. So it's basically saying what you can do is introduce a process of review. Section 21A and 21B do that, and as I've said, they're in
38(1)(a).
Yes.
Is that
but
for and in connection with reviews, or is it in connection with appeals?
But my point is this: when first of all we have the total point, and in my submission it's powerful, which is if what you do is say you can only bring an appeal if you meet these particular conditions, that's a paradigm exercise of the section 1241B spelt out in section 1242A2. That's the first point. We say it's absolutely within those words, and Total supports us on that. But the allied point is this, that this whole provision is saying you can make provision for and in connection with reviews. In other words, introducing a review process. Yes. And it then goes on to say that you may also make provision about in connection with appeals. No need for the word for there because there's already rights of appeal. But it then says, reading it in context, it can make provision about the circumstances in which or the time within which an appeal may be made. And it's plain in my submission that Parliament had in contemplation that would include needing to apply for a review, because that's addressed in this very section.
Yeah, but the point is it's not expressed in those terms you've just given to us in this section. You have to, I think the argument against you is it doesn't say so in terms, i.e. expressly. You have to infer that that's what Parliament meant when you are interpreting 1242A2.
Yes,
and that leads on to the question about how do you interpret a Henry VIII type provision.
Well, yes, and that is the submission which is made, and it's wrong in my submission. A, because Total tells us it is, and B, because the language is clear. It says provision about the circumstances in which an appeal may be made.
Would you like just to give us the specific passage, read it out, reference in which part of Lord Justice Moses' judgment in Total?
Yes, it was in my oral submissions, but I think it's paragraph 21. It's not correct to say that each and every possible exercise of a power needs to be spelt out, and in my submission, given the clear wording of section 1241B, the clear wording of section 1242A2, and the fact that this very provision concerns the ability to make connection for and in connection with reviews, coupled with the fact that, as I've submitted, all that section 38(1)A does is say you need to apply for a review before you can appeal. So those 4 points, coupled with what Mr Justice Swift says, well, that's not really an interference with a fundamental right. It's perfectly reasonable. If you take all of those points together, they completely undermine my learned friend's carefully crafted submission, which involves a series of building blocks, but which takes one to a position which is wrong, because this case is actually a lot more simple.
To be clear, you're saying that by saying the circumstances in which an appeal may be made,
yes,
that is an express provision.
It is.
You're not relying on necessary implication.
No,
that's what you say.
Yes, I don't need to. And I think the point that my learned friend raises, which is, well, yes, but, you know, you've got to be very specific if you're interfering with a core right.
Isn't that the point that Lord Justice Moses makes in the first sentence of paragraph 22?
He does, but that's getting rid of an appeal right altogether, and we know Mr Justice Swift, this isn't getting rid of an appeal right. This is akin. You've got to apply within X period of days, or you've got to pay in money, or whatever it is. Mr Justice Swift tells us, no, that's perfectly reasonable to require somebody.
So this is not a provision which revokes or removes a right of appeal.
No, it does not.
What verb would you put in there? What is it? What is?
It places a condition. It sets a condition before the appeal right can be exercised, just as Lord Justice Moses discusses in his decision in Total. Because otherwise, it's the same. You can't appeal unless you do it within 28 days. If you don't, you've lost your right of appeal. But that's not abrogation of a right of appeal. It's the language Mr Justice Moses uses in paragraph 21 and 24 is the circumstances in which an appeal can be entertained. It sets out the circumstances in which an appeal can be entertained. And an appeal cannot be entertained until the department concerned has made its review decision.
Before section, the mandatory review position came in, there was a right of appeal.
Yes, and what would happen?
So the consequence of these reforms was to what?
It was
revoke, remove, restrict,
no, it was
confine.
The right of appeal remains, but you need to get the review decision first. And that's what Mr Justice Swift is saying in Connor, and I would commend those paragraphs to the court and also invite the court to look at why Mr Justice Swift decided that there was a breach of Article 6. It was simply...
Sorry, which paragraphs in Connor?
28 to 31.
Thank you.
What Mr Justice Swift decides in Connor is that there's a breach of Article 6, not because people have to ask for a review, but because they're not getting their money while they wait. That's the only reason for his decision. So it's all very well to say, oh, well, it's a breach of a fundamental right to make somebody apply for a review. There's no authority in support of that proposition. It goes the other way. So we say it's a clear enabling power. And it's precisely as described by Lord Justice Moses. It's the circumstances in which an appeal can be entertained, but there is a right of appeal. What you need to do is get the decision first. So just deal then with the authorities as briefly as I can.
Well, okay. Yes, of course.
As I've said, there's a danger in looking at other statutory provisions. First of all, I won't invite the court to turn these up, but I'll give the court the paragraph numbers.
I mean, your point on Total is the answer, you say, to all the authorities that Mr Burton has cited.
Yes, and my point, which is...
Plus Connor.
Plus, yes, different statutory language, plus, look, this is not an interference with a fundamental right. It's needing to get a review before you go to appeal. Let's keep that in perspective and not...
So it's not a fundamental right.
Not that. That in itself is simply requiring somebody to apply for a review, and it doesn't...
So you accept... So break it down. Do you accept that the right of access to the tribunals or the court is a fundamental right?
Yeah, the cases say that. Just that it's not abrogated in this case.
Well, it's why isn't it restricted?
It is in the sense that there's a condition which applies before it can be exercised. But here we're talking about ultra vires. We're not talking about Article 6. So the fact that there is a condition before you can exercise a right of appeal does not mean, if, for example, I lose this case and I fail to apply to the Supreme Court in time, I've still got the right of appeal. The right of appeal exists. I just won't have... the appeal won't be able to be entertained if it's late, which is precisely how Lord Justice Moses categorised it.
But given you've already had access to the courts, that's not sort of quite the point, isn't it?
But this person
I think the point that's been made against you is that if you're right, the sole gatekeeper of access, of the exercise of the right to the fundamental right to access the courts or the tribunal is HMRC.
Well, not in terms of Section 38(1)A, because what Section 38(1)A says is you need to apply for a review and have the outcome of it. I suppose if you make an application and HMRC says, well, we're not going to answer it ever, that would be a problem. But that isn't really the issue. Insofar as my learned friend seeks to draw in complaints about other provisions, those provisions are intra vires. So, again, all of these cases about fundamental rights, they need to be looked at, A, in relation to the specific statutory language, and B, the particular consequence of what is being done. So PLP, could I just ask the court to look later at paragraphs 29 and paragraph 36 for the reasoning in that case? This is the case about legal aid residents' rights, because the court is looking at the entirety of the provisions and saying, well, the provisions do X, you can't then use this broad power to do something which is different from those earlier provisions. So that's PLP. In terms of Salim, paragraph 127 and 130 was the statutory language at issue, may make rules for regulating the exercise of rights of appeal, and they also look at the words may if dissatisfied. It's that language which they say means that having a 5-day time limit where somebody couldn't possibly meet it because they haven't actually ever received the relevant decision interferes with a fundamental right, and therefore means that those specific provisions may make rules for regulating the exercise of the right of appeal, that particular provision doesn't fall within scope. That's very different, again, on the facts from our situation. I won't repeat it again, but essentially for the reason Mr Justice Swift gives, all that you're doing is saying to somebody, you've got to wait until a mandatory reconsideration decision is made, and making them do that to fundamentally protect the tribunal system. So it's of a very different order. Similarly, Unison is talking about access to a court. Again, one needs to be careful here to look at the whole system. Unison is about fees. There's no possibility of JR. If you couldn't afford the fees, that was the end of your employment tribunal case. So you can't exercise the right of appeal. I've already said this morning that in relation to the time decision, there is a right of access to a court in terms of judicial review. And so far as the appeal is concerned, and again, to answer a question from my Lord Justice Snowden, the person has the right of appeal. They just need to wait for their mandatory reconsideration decision. So all of those cases turn on the language at issue and the specific consequences of what was done. In this case, we've got authority on the specific language at issue, see Total. Just then briefly, I've taken the court to Connor already, just to make a point about the statutory context in CJ. And as my lady said, the provisions are different. So Section 12 of the Social Security Act is a provision which deals with the right of appeal to a tribunal. So necessarily, when one is inserting something into that provision, one won't necessarily take the same approach as one takes in a different statutory provision, which is in Section 124. So that's the first point. And the second point, is the point that I've made, which is essentially what you're being asked to do is say that requiring somebody to have a mandatory reconsideration before their appeal is so unfair, so contrary to their fundamental rights, that it needs to be struck down as ultra vires, notwithstanding the clear terms of Section 124, and we say that is simply wrong. The debate on remedy in my submission underlines the force of the points that I am making. The reason that we are trying to put square pegs in round holes is because there's nothing wrong with Section 38(1)(a). But it is certainly right that either it's within the powers or it isn't, There is some mention in my learned friend's skeleton of a case which seems to be a rectifying construction. I'm sure this court will be aware that the court can't act as legislature, and there isn't scope for a court to think, well, let's redesign.
Well, this sort of declaration that was being discussed might fall foul of that principle.
Yes, exactly, because what it's doing, the reason that my learned friend is effectively jumping through hoops is because he's doing what I say he's doing, which is pulling together a patchwork of points to come up with an ultra-vires argument, which is effectively inviting the court to strike down section 38(1)(a), which does something very simple and something not objectionable.
I know you say that the whole, without the teeth of section 38(1)(a), there's no point to section 21(a) and 21(b). I get that. If you're wrong on that, so just bear with me for a second, if you're wrong on that, as I understand it, Mr Burton just says, you just make a declaration that what is ultra vires is section 38(1)(a) and the associated cross-reference in section 38(1).
Either way, it ends up
But that would, if he were right, that would be the way to deal with it.
Well, it strikes down section 38(1)(a), and there is no longer any requirement to...
Yeah, I know that.
Yes.
Sorry.
Yes.
That was your first point.
Yes.
But as a matter of giving effect to as a matter of giving effect to a decision which would be against you, which I know you don't agree with.
Yes, I accept.
Is there anything fundamentally otherwise wrong with that?
I think what the court would have to do is say the amendment made by the 2014 order is ultra vires the enabling power.
Okay.
Yes. That could I just turn my back for a moment? I'm also asked to make the point that there is what in the first tier tribunal rules there is also no time limit. It's a point we footnote in our skeleton. So there will be
no time limit.
There's no what we will end up in the rules don't envisage a situation where there isn't a requirement to have a mandatory review first, which will end up with the rules needing to be amended as well.
Is that in your skeleton?
It is, I think, made as a footnote point. Yes.
Well, I thought I picked it up.
Let me give.
It's in your supplementary skeleton, one of your footnotes.
Footnote 5 to paragraph 25.
There we are.
On page 10.
Yes, I knew I'd put it somewhere. Footnote 5.
Thank you.
The final point then that I make on Article 6, very quickly, I promise, my learned friend refers to right and says, well, you've got to look at the process as a whole. We refer in our skeleton to various cases which include right, but the point is, yes, one does need to look at the process as a whole, and the process here is one which includes the statutory provisions that I've described, which also include a clear Section 17 notice, which the person has an opportunity to engage with before there is even a Section 18 decision. So that's part of the context. But again, I won't repeat the submissions I made this morning on the discrete time issue. We say judicial review provides suitable access to the court. Oh dear. It's 5 to 5.
One person's fault. It's not your fault. It's mine and Mr. Burton's, as it were. I'll take the main part. Well, we're going to rise for just a couple of minutes just to take stock, and come back in a couple of minutes. Thank you.
All rise available. I think what they did is before So once there was an appeal, they would then, once an appeal had been made, they would then look at.
No. Forget about appeals. Just ordinary claim reports.
Well, yeah, there's all the
and
whatever the power.
change of circumstances.
Yeah, whatever the powers are to make change decisions.
Yeah.
Yes.
So they're using the concept of supervision and revision.
But I
Because
think
that's
they
all-
don't
that's
use
the
those. They don't use those words, do they? I think that's what Ward says. It doesn't have the same. It's not the same as social security. That you don't have the same architecture of revision and
Well, I
supersession.
discovered at lunchtime it's quite hard to get to the
I mean,
bottom of some things.
I don't think I can
From
say any
memory,
more.
From memory, the 99 regulations and decisions of appeals started to insert the board. Remember? So that's why I thought, they're just using the same.
Well,
system.
I think all I can say about that is what Judge Ward says in ZM, which is
Well,
I
heard that.
you don't
What
use
I was
revision
gonna-
and supersession.
What I was going to propose, because they were talking about it, is that we could do, I hope, an agreed note on
Do we need it?
whether the concept of revision existed for tax credits before this change was made.
Do we need
Because I
to-
thought it did.
I think the point of them going out now is to decide whether they want anything like that from us. So we'll see here.
Yeah, I mean, I
whether
don't know
they-
the answer to that. What I know is that before the new rules were, what I've been told is before the new rules came in, it was after an appeal had been instituted that it would be done under tax management powers. I'm sure there's power. I mean,
Well, that definitely exists. So we've got the provision for that.
yeah. So that
Well, I just wanted whether she was correct to say there was no concept of revision. I didn't
well,
realise that was the case.
I don't think I missed that point then, because I've taken them already to section 21, which is about revision on grounds of official error. I haven't gone through all the other revision powers, but I think it's more.
Well, I think she was
I mean,
saying
we may
there was no equivalent
Well, we may
of
be
the
aligning
social
two
security
things.
power to change things
Well,
through revision.
I think we may be aligning review generally, and it's good that happened only now. Mandatory and
Well, all
a
I was thinking
mandatory
was digging
reconsideration
out what
type.
was there and saying, well, that's what they had. There you have it.
right. Okay. Well, I'll let you propose that and do the first draft.
I think we are going to have to tell her that because she seems in some way concerned.
I think then I've misunderstood.
It's all
So
right.
I'm happy for
Well, what
you
do
to.
your panel of experts behind you
Well,
say?
they tell me that before. I mean, there's always been,
From 2002 until
Well, I've already
2014.
said there's a revision power, but I think she's talking about was there any process of mandatory reconsideration?
No, I agree there wasn't one of those.
That's
Well,
what I
what it-
understood her to
well,
be
hold on a
getting
minute,
at.
because the revision process in Section 9 in the Social Security Act is revisions.
Yeah, it's just an at-large revision.
But that's the point that she's drawing a distinction between, isn't it?
So
Because
is
I don't think
there no supersessions in
I don't no, well,
tax?
that's what Judge Ward said. I mean, were there just at-large revision powers? There's section.
Do you revise, do you supersede?
Not that I'm.
No.
You don't supersede, right?
There are revisions that don't change a cert powers. So section 15 of the Tax Credits Act allows you to change the award based on what's reported to you.
Well, that's if there's a specific.
Are you waiting for
report.
us? No.
It's not.
Waiting for the judges to come.
I was
It's
just about
not
to say, sorry, you definitely don't wait for us babbling away.
It's not a general. Our heads all hurt.
But so is the answer we don't actually know if there were pre-existing rights to request?
There's nothing.
It's the request point. That
There's
It sounds
nothing
like
like-
there isn't an equivalent
Yeah,
set
I
of
think that's right. There's no equivalent of what's now in 21A. There was
no,
no.
I'm not
equivalent.
asking that. I'm asking was there an equivalent to what is in Section 9 for DWP, which
Well,
I
no,
can
that's-
ask for it to be revised.
The
At
answer
any
coming,
time.
the
At any
answer
time.
coming back
So
is
no,
no.
it's a
No.
different structure.
Not
So
You
if I-
can report a change,
Yeah.
and that change, depending on what it is,
Yeah,
will
that's
lead to.
Yeah, but it's not or official error.
Yeah. I mean,
But there isn't this. This introduces the general
Yeah,
thing.
it looks like it is slightly different. It shows you how much I know.
okay. Well done.
So it might be better not to avoid this.
That's tricky.
No wonder nobody likes tax credits in the welfare benefit world.
Prize available.
I might say that.
Well, thank you all, both for your submissions. Thanks to all counsel and all those who sit behind counsel for their contribution. What we'd like to, we're going to reserve judgment, but we think in fairness, both to the issues and to the parties, that we ought to provide an opportunity for further submissions in this context. First of all, Mr Burton, we'd like you to have the opportunity to give, and those who sit behind you, to give further short written submissions on the question, on the remedy point, which we feel hasn't been covered fully either in your skeleton argument or in your submissions today. That's no criticism, it's a difficult point. But we'd like your submissions on that in 7 days. Ms Smythe, and this is not intended as a criticism of Mr Burton, we have a strong sense that in some respects Mr Burton's submissions today have gone beyond what was canvassed anticipated in his written documents. And again, I stress I'm not criticising because it's a complex case. So we'd like to give you and Ms Elliott the opportunity to respond, both on the remedy point and also generally. Not to raise new issues or to cover ground that's already anticipated, but anything new. I'm very conscious, for example, that you were alluding quickly to points raised in the authorities, and you may, on further consideration, want to develop some of those. Again, we're not going to put a page limit on, but please exercise restraint, and we'd be grateful if we could have those by 7 days after that. So it's Wednesdays. So next Wednesday for Mr Burton, the following Wednesday for you. Is that any comments on that proposal?
Not from the respondent, thank you very much.
No, thank you very much.
No, thank you, my lord.
Yes, could I just reiterate, as far as you're concerned, we're giving you a bit more latitude than we might normally give. It's intended to be effectively developing a reply.
Yes, and I will do my utmost to ensure that that privilege is not abused. Thank you, my lord.
Good, thank you very much. All right. It follows inevitably that we'll be reserving our judgment. It also, I'm sorry to say, we won't be able to hand down judgment this term, obviously, because there'll only be 1 day after we receive your documents. So it'll be some point next term. When you get the draft judgments, as you will in the normal way, please bear in mind the rubric. They're confidential to those persons to whom they are. The draft is circulated. Remember, there's now a strict warning at the top, which you have to comply with. In due course, when we hand down our final judgment, we should want to hand down an order. Please would you endeavour to agree terms of the order consequential to our decisions. If there's any issue between you at that stage, we'll resolve that issue in writing on the basis of short written submissions. Is that all clear? Thank you all very much.
Court prize available. He said come to his room. Got more? They're free.
So this is the authorities, yes?
Yeah.
Yes.
No, he's up. He's two.
No, I think that was
Yeah, that's the court bundle and the supplement.
that's all our point is.
And that. All right?
Yeah, that's good, thanks very much.
But yeah, I mean, what we say about that, because that means
Your judges, Falk, Baker.
But But anyway, let's not have the argument.
No. But it doesn't mean that.
I mean, if you put, say I haven't objected to you making that point, if you want to make it in your written thing, that's not a problem at all.
Yeah, okay.
And we'll address it.
I just kind of cut down. I mean, it is quite an there are cases around it, not on it. And so, in some ways it's quite an interesting book. I just wanted to make sure that they didn't walk away thinking that